All right, a little bit of an early start today. This is Uncomplex number 8, and we're leading into the August, uh, what do we call it? A trip, the big convention in Orlando, um, maybe like an Odyssey. So I'm looking forward to being in Orlando this next week. I wanted to lead off today just by reminding folks what we've got going on with our OJCC speakers next week. On Sunday, the 18th, we're going to have a presentation in the mediation breakout, which will be Adam Ross speaking about best practices for attorneys. I think they may have changed the speaker on that, but it'll be one of our speakers. Uh, Also, at the same time, across the hall, we've got Judge Greg Johnson and mediators Breslow, Ember, and Blatt, and they're going to be talking about self-determination constraints in mediation. And those are going to be increasingly, I think, prevalent. Um, I don't think it's going to be a consistent problem, but I think we're going to see it more so than we have in the past in light of the MEAC opinion that's come out. At 1 o'clock on Sunday, we've got Kate Marshman, one of our mediators, talking about the latest in AI changes, artificial intelligence. I made the mistake on another edition of the Uncomplex by using the term that caused my cell phone to get excited and start talking in the background. So I won't use that, but it's hey something. And then there's technology and AI. AI is coming. I don't know to what extent and at what speed, but it is coming. And in some instances, it's here. At 2 o'clock that afternoon, boy, this is a great one. 2 to 2:50, you're going to see in the mediation program negotiation techniques as observed by the mediators. And if you think about the way workers' comp works, 81,000 petitions filed last year, folks. I didn't realize my camera wasn't on. 81,000 petitions filed last year. Less than 1,000 of them go to trial. Where are these cases getting resolved? They're getting resolved in mediation, and that's just plain and simple. I would suggest to you that knowing how to do a good job in mediation is really important. We'll talk about that more in a minute. Sunday at 5 o'clock in the Anaheim, Atlanta, and Boston rooms in the Hall of Cities there on the main floor, we're going to have an OJCC meet and greet. I've heard from so many people that tell me they're coming. We're going to have folks from the Division of Workers' Comp there. We're going to have our judges and mediators there. We're going to have so many members of the public who say that they're coming. In today's world of Zooming and phone calls, I would suggest to you that is really a phenomenal opportunity to actually shake somebody's hand, spend a few minutes chatting with them about who they are and where they're coming from, and just better appreciating the human part of this practice and of what we do. On Monday in Grand Ballroom 10 at 1 o'clock, we're going to have a meeting of the statewide nominating commission. They're going to be interviewing judges Anderson, Arthur, Kerr, Lewis, and Massey. If you want to know how people get in the seat and how they retain the job, I really would encourage you to come by and watch the commission work. Really interesting to watch, and I think very educational. On Monday afternoon, there's a great program on harnessing the power of artificial intelligence and medical legal issues. That's at 1:15 in Grand Ballroom 8A. I was supposed to be on that panel. I had to beg off, but I'm sending a replacement to speak in my stead at that presentation, who is literally the best informed lawyer regarding artificial intelligence of any. And I think that'll be a great program. On Tuesday, we're going to talk in the same program at 9 o'clock in the morning about revolutionary things in workers' comp regarding AI, outcomes, interactions. That's going to be fascinating. I'm on that panel. And following it at 10:15, we're going to talk about, I'm sorry, at 10:30, we're going to talk about case law from across the country, a case law update on all 50 states. And I'm sitting on that program. You don't even have to change rooms. That'll be interesting. Programming against me, if you want to listen to somebody else talk, at 10:15 down in the Crystal Ballroom J2, Judges Anderson and Pitts are going to be talking about motion practice, attorney's fees, and ethical pleadings. Boy, that would be a great program, particularly for younger lawyers, as you're trying to sort of pick your way through best practices. And those are two excellent judges to listen to about what they're seeing out there in the world. In that same room, J2 at 2:15 in the afternoon, Judge Kerr is going to be speaking on statutory employment and the problems and the complications that that can bring to the table in terms of contractors, subcontractors. That's going to be a really intriguing conversation. I would encourage you also in every one of these programs and presentations, there's always opportunities to ask questions. I can tell you as a presenter, and I've done this a few times, it is always rewarding when someone has a thoughtful and a reasoned question that they want to ask at the end. So I would really encourage you, if you don't want to ask it in front of everybody, that's fine. Come up to the table afterwards and say, I was thinking about this and this, and I just wanted to ask you what you think about that. Really very positive. So, what else is going on in the world of workers' comp? Some of you may have noticed in the national news, a big story this week is that politically, various folks are grasping onto the idea of no tax for tips. And that's intriguing. I don't know that they'll ever get it passed. It's an idea. So when would it become of interest to us? Well, obviously it would take a act of Congress and it would take a presidential signature. But why would it be important in workers' comp? And I wrote a little bit of a detailed blog post on this week, but the bottom line is that our AWW statute is specifically and intentionally tied in terms of gratuities to taxable reported income. And so if the federal government changes their definition of income, provides some exception for gratuities, I think it's a valid question for the workers' comp community to ask regarding how might this affect average weekly wage calculation? And would we see the Florida legislature step in to provide clarifying or instructive language in terms of altering our statute in light of that national change regarding gratuity should it come to the fore? I know that I probably obsess over workers' comp more than most people. I'm pretty sure I'm not the worst of the obsessors, but I'm probably on the top of the list somewhere. But things like this hit the news persistently. And I think as an attorney representing anybody in the workers' compensation system, you just sort of have to be attuned when you see these news stories to think, is this or is this not likely to be a challenge or a problem for me in representing my clients? Might this cause this or that? Might this support me in this way or that way? I think those are valid questions to ask, and I encourage you as attorneys to maybe ask yourself those questions at least sometimes. Premiums went down last year. Work comp premiums in Florida went down last year 15%. We are this time every year sort of waiting with bated breath because the National Council on Compensation Insurance, NCCI, based down in Boca Raton, Florida, is going to issue its recommendation literally any day. And we may see the potential is there for a rate increase this year. That would be the first rate increase in a number of years. And I pointed out because always you hear about rate increases on the backside of news stories and people start asking questions. What does this mean to me? And that may be true if you're representing injured workers in terms of the way that their employers may be perceiving or experiencing the workers' compensation system. It may not have a direct impact on their case, but it may impact the way people feel. And I think being able to explain to an injured worker both that these changes can occur and that doesn't change the volume of benefits to which he or she is entitled because that locks in on the date of accident, I think is a good base knowledge for people to have. On the employer carrier side, of course, the question will be, what does this mean to me in dollars and cents? And what's this going to do to us downline in terms of risk? So from both sides of the table, I think there's a reason to be somewhat tuned into that news. And as I say, we're going to see a report drop on that probably in the next 10 to 15 days. In a few years, it's come out right in the midst of the comp conference just to make things interesting. We don't have, as we have in some years past, as of yet, knock on wood, we don't have any appellate decisions coming out the week before the comp conference that are likely to or susceptible to maybe creating some excitement or some curiosity next week. But I would encourage you to maybe keep an eye on your appellate decision releases. And I always tell Florida people, if you're interested in the fact that that can happen, there's a great program in the big book that you can go to that's the case law update. That case law update is staffed with some of the big name lawyers in the state, and it's right there in your book. It's also available online. And so if the first DCA were to drop an opinion tomorrow or the next day that is exciting and newsworthy, I would almost assure you that you'd get a chance to hear about that at that case law update. And it's probably worth a few minutes of your time to stop in and see what they're talking about. Why might we see a rate increase? We've got the grand scheme of economics affects workers' compensation. And that becomes a bit of an internal inconsistency that I think is good for folks to understand. If you don't have any background on this, the idea is that prices rise over time. Inflation happens. Even the most inflation-resistant portion of our population and leadership is somewhat agreeable to inflation running at a 1.5% to 2% annually. They sort of look for it to increase prices, and they sort of accept it. The fact is, prices change over time. I struggle to admit this, but I'll go ahead and make a public record of this. I can remember the day when I would go to a fast food restaurant and I would order 2 cheeseburgers, 1 French fry, and a drink, and I would pay over $1 and they would give me change. That's really embarrassing. Today, you're kind of bragging if you can hand over a $10 bill and get some change in that sort of exchange. So inflation happens. What most folks don't realize, though, is that the people that count these numbers also keep track of something called the medical inflation rate or the medical CPI, Consumer Price Index. And what we know is that over the last 50 years, on average, that medical CPI is increasing at a greater rate than the CPI generally. So what does that mean, folks? That means the medical costs in our society are rising more rapidly than the cost of the value meal down at the fast food restaurant. That means that medical in our workers' compensation arena is probably increasing as a percentage of the spend, the dollars that are put back out into the market by a carrier or an employer. So if they're paying benefits to an injured worker, back in the day, medical and indemnity used to be about 50-50. So if the carrier was paying out $1, they were paying 50 cents in indemnity, 50 cents in medical. I believe that the current ratio is closer to 65 to 70% of the dollar being spent is going to medical. Now, I've had others in the marketplace and many very bright people tell me that they think I'm dead wrong, that they think I'm shooting low at 70%, not high. So what that tells you is that the medical costs are increasing in the marketplace, and that's affecting these premiums that are being charged by the insurance companies. And to some extent, it may put the squeeze on the negotiations in terms of what folks are willing to pay to settle a workers' compensation case. Now, that's not isolated to workers' comp. Let's be fair. Medical comes into a lot of other areas of the law, personal injury and others. And so there are different places that we might talk about this medical CPI being a interesting and intriguing topic that maybe you need to keep on the front of your brain a little bit. How is it different in workers' comp? I would ask you to remember that workers' comp premiums are calculated based on loss. Well, all premiums are. But in workers' comp, they apply then to the payroll of the company. So the employer's payroll is ingrained in that premium negotiation and calculation. And what does that mean? Well, folks, payroll is not increasing at the same rate as the medical cost. And so that means that premium may at some point struggle to keep up with the spend, the benefits being paid out. And so at some point, it's likely that we will see these premium rates change. Now, what happened in 2024 that makes me say that we may see it this year? Um, the NCCI that I already mentioned has made some thumbnail predictions back in the spring during the legislative session that we could see rates turn upward based upon the fact that the legislature passed a bill that changes the reimbursement rates for doctors in the workers' compensation system. And everybody that practices workers' comp needs to realize that we have a fee schedule. And the way the fee schedule works just changed. And so we're going from a process that always involved what we called the three-member panel and their recommendations, which always included legislative consideration and approval for those changes in medical reimbursement. And we've moved away from that. Now, some medical cost still has to go through that process and be approved by the legislature. But a big chunk of medical reimbursement is now being amended into the manual each year about July 1st by the Division of Workers' Comp. And so we've seen years where there was no adjustment to our reimbursement schedule. We've seen years and years pass without adjustment. And when that happens, we start to hear from medical providers about how workers' comp is squeezing their practice and how they would rather see personal injury patients or group health patients or Medicare patients because of the differentiation in what they can get paid. Uh, Everybody that practices law probably understands that. If you can get X dollars an hour doing workers' comp, but you can get 2X by representing folks in family law, you may be lured towards doing more family law and less workers' comp. And a medical practice is really no different in that economic foundation base. So you've got to be thinking, is the inflation of the indemnity, the payroll, going to be sufficient in terms of collecting premium to match that higher or sharper increase in medical fees? That's in a broad sense. This statute changed the reimbursement for non-surgery medical codes from 110% of Medicaid to 175%. Now, you can do that math in your head, but that's about a 50% increase. They've increased from $140 or I'm sorry, 140% of Medicare on surgical codes to 210%. And that again is about a 50% increase. The doctors were limited to $200 an hour in terms of testimony. That's going to 300. That's again a 50% increase. So the fact is that some believe that this means doctors, hospitals, other medical providers are going to charge more for services and for testimony, and that that's going to drive cost. And that if that's going to drive cost, that means the premium has got to be increased in terms of the rate, not just the experience. So that's why perhaps this year is the year. You may see a rate increase. And just to remind everybody, when I sit here and I talk about workers' comp, I keep an eye on the chat room. I'm watching for your questions. And if there's something that you'd like to talk about in terms of workers' comp, I'm happy to try to address your questions. Keep them general. I don't address cases and I don't give advisory opinions. Just like my blog, you can't walk into a hearing room and say, Judge, I should win because Langham said so. Um, that's a great punchline. Saying because Langham said so will probably get you some laughs, but that's probably all that it'll get you. But I do try to help people understand what's going on and what they might be able to accomplish and do differently. What else is on my list today? The greatest, it got me thinking, looking at these things that folks are going to be talking about at the conference, our team, the mediators and specifics. Um, how do you mediate effectively? And I've got some tips for how you mediate effectively. And some of it you may find helpful, some of it, I don't know, perhaps not, but I'm going to give it to you anyway. Number one, if you want to succeed at mediation, number one on the list is prepare. Uh, the worst mediations from either side of the table are the ones where somebody shows up and they don't have any idea what's going on in the case. They may have an idea of where the case was 6 weeks ago or 6 months ago. You need to show up and you need to be conversational about what's going on and what it is you hope to accomplish. That's way different than personal injury or medical malpractice and these other kinds of cases where you're always thinking about a lump sum total resolution at mediation. In workers' compensation, a great number of our success stories are issue resolution. So if what the client really wants is to get this petition addressed, right, or to get this doctor authorized or this test, then you want to prepare maybe a little differently and you want to come in focused on what it is you want to accomplish. And so you need to think in the broadest context in workers' comp and how can I, in this mediation today, make progress for my client? How can I bring this matter forward? And that's true claimant or defense, right? So you've going to have to prepare. What does preparation involve? Well, first of all, it's the lawyer becoming acquainted with and comfortable with the litigation, obviously. What is less obvious is that you have to prepare the client. Uh, some of the some of the worst mediations that I've ever attended or conducted, and I've done a few of those, were the instances where somebody comes in and they make unrealistic, sort of blustering statements that are intended to influence the other side of the table, but they end up having more of an impact on the blustering side of the table. What's an example? If you're representing the injured worker and you come in and your opening statement is that this injury is catastrophic and there's just no way to get around that, and so the carrier should pay you $1 million. Okay. The carrier may very well need to hear that number so that they can appreciate your perspective on how serious this is. But if the injured worker is not prepared in advance and she hears $1 million, you may have trouble getting the client to understand that that was a negotiating ploy. It works the other way. If the employer carrier comes in and says, this is not a compensable case, or this is not a serious case, and we're going to offer nothing. Okay, this is a $0 case. Maybe that's important for the injured worker to hear, but if the client, if the employer carrier is picking up on that negativity or that perspective, and they get that locked in their brain, getting them to come up from the 0 point may be extremely difficult. That's part of preparation for mediation. The lawyer needs to sit down with their own client and explain there are things that I'm going to say today or tomorrow, whenever mediation is, that are going to maybe sound really positive to you, but I'm saying them to try to influence the other side. I'm trying to help the other side better appreciate where we're at. Please don't take some of these things I say as absolutes. For example, when I say the case is worth $1 million or when I say the case is worth zero, take that with a grain of salt. Understand that I'm opening a negotiation, a back and forth, and that that's not where we're going to end up. Where we start is rarely going to be where we sort of pack up our bags and go home. If you don't prepare the client for that, okay, whether that's the opening salvo monetarily, whether that's the absolutely it has to be Dr. Smith or it can't be Dr. Jones, you need to prepare the client so that he or she can appreciate and understand that mediation's a process. So if you're going to be effective, A, you've got to plan where you're going. B, you've got to let your side of the table understand what it is you intend to do, where you see the absolutes, where you see the negotiable points, and how you want to proceed. That's going to prepare their brain for those caucus sessions when you can talk to them about, well, here's where we are, here's where they are, they want, you want, how about this, and talk about how you might compromise the case or the claim. If you don't do that in advance, you can spend an awful lot of time. Um, I'll give you a great example. A very prominent, very successful lawyer that I mediated against a million years ago came in at trial one day. The mediator, not at trial, at mediation one day, the mediator gave him an opportunity. Would you like to give us an opening? And he didn't have one. His opening was everybody needs to understand that this is a multi-million dollar case. And since my client knows the case better than I do, I'm going to let him give the opening. And 30 minutes later, that injured worker was still talking. Uh, he said some things in opening his case that, boy, I don't think I would have said. And I probably would have cautioned him against saying. But he wasn't a lawyer. He was an injured worker. He had an emotional tie to the case. He did have a significant injury, and he really wanted to tell his story. He hadn't been prepared by his attorney. The attorney hadn't prepared well enough to give the opening, and I think that that was troublesome or damaging to the process because when we broke into caucus, my client and I then sat for about an hour and 15 minutes waiting for the mediator to come back. He spent a long time down the hall trying to get back on track so that we could talk about the case. So, is that purely going to happen on the claimant side? Absolutely not. If the defense lawyer doesn't prepare the defense side and defers the opening or any other else to the client, I think you're setting yourself up for creating problems. You're going to make the mediator's job likely more troublesome or more difficult, and that's going to hurt you in terms of moving the case down the line. What else is important in mediation and reaching good agreements? Years ago, I was introduced to emotional or psychological testing, and there's a whole bevy of products out there on the market. One that is very simple to use, and you can find lots of iterations of it, is called the True Colors test. Now, if you talk to psychologists, a lot of them will tell you, boy, that's not the one I would pick. It's a little too shallow. It's a little too glossy over the details, and I don't have a problem with them saying that. The reason that I find it helpful is because it's very simple to use, and it will help you sort of understand how you think about things. And as you see people's reactions to your arguments or your ideas, it sort of helps you to understand what does or doesn't appeal to the people that you're talking to and negotiating with. You cannot, write that one down, you cannot change the way other people are. You might change their mind, but if the attorney across the table from you is a numbers person, then you're going to do better bringing numbers. If the person across the table is an emotions person, you're going to do better bringing emotions. Um, it, it's back to that old saying about lawyers. If the law's on your side, argue the law. If your facts are on your side, argue the facts. You're trying to make that decision with this opponent. What is it that appeals to him or her? How can I best convince them to see things my way? And that's what a lawyer's job is. You're making arguments and you're making positions, and you're trying to pull the other side towards you in terms of your position, right? And at the same time, they're trying to pull you towards them. It's a give and take. So the better you are at understanding sort of what might motivate them. Is this a numbers person? Is this an emotions person? Is this a person that likes to see what the rules say? Is citing a rule going to convince them they should agree with me? Then, if so, get the rule book out. If this is not a person that's enamored with rules, their response every time you bring up a rule is, yeah, I don't care about rules. All I care about is doing the right thing. Then maybe you, instead of rules, shift and talk with this person, the other side, about what the right thing is. And you can have your own perspective on what is the right thing, right? And so think about what appeals to them. Probe their side of the case and see if it's the facts. Probe them with different perspectives on the facts. If they don't care about the facts, you're probably not going to get anywhere arguing about the facts. If they're focused on the law, get ready and talk about the law. So over time, you'll find that we all have some inherent preferences in terms of the way we view things and view the world. You have to fight against those biases, but recognizing those predilections in your opponent can be very helpful in trying to get them closer to your side of what you'd like to have accomplished. And that's true whether you're claimant or defense. You're just trying to do a good job of being what your client has hired you to be, and that is a negotiator in the mediation process. What do you have to put on the table? When do you put it on the table? In what quantity, right? With what absoluteness do you put it on the table? And the mediators that practice in workers' comp, in my personal opinion, are absolutely phenomenal at advising lawyers on how to make those decisions, when to go here, when not to go here, what are the emotions in the other room, what are the feelings, when is the right time to this or right time to that, is this technique going to work here or not work here? They're in a great position to tell you how they feel about that. Outside the opening session, they're getting much, much more personal experience and exposure to those other parties than you're getting. And so they are your eyes and ears to some extent, and you need to listen to them. Don't let them get between you and your client, of course, but you need to listen to what they've got to say. So those are the things that have sort of been on my mind this week as we head into the workers' comp conference. Um, it astounds me how many times people tell me, oh, that mediation program on Sunday, I never go to that. That's for mediators. Um, they say the same thing about the medical programming. Oh, I don't ever go to the live surgery. I don't ever go to the orthopedic awards. Um, I can't learn much there. Wow. Um, Understanding how mediators think and what they see as the problems in the system is hugely valuable if you're going to be in mediations. Understanding how doctors perceive patients, how they perceive medicine and science is hugely important if you're going to deal with doctors and take their depositions and try to educate yourself and your client, right? And eventually the judge about what the medicine is, what it actually says, where the science points us. Boy, you can get a lot of that in the orthopedic breakout. You can pick up on who these folks are, how they think, and do they think differently than lawyers? They might. Do they think differently than you or I? Only you can judge that. But having an appreciation for how they think can be just excruciatingly important in terms of being better prepared to know how to negotiate and to know how to advise your client and help your client to deal with this process. Finally, I would just close with the fact that whether you're in trial, whether you're in mediation, whether you're in a deposition, the fundamental challenge that I personally am hearing the most negative perceptions about comes down to preparation. Are you ready to do the job that you've set out to do? And I think it is critically important before the deposition, before the mediation, before the trial, you need to be prepared. You need to loop your client in, and you need to make sure everybody's on the same page. Uh, there's nothing worse than a surprise. There's nothing worse than a bombshell out of nowhere if you're hoping to make progress in your case. So prepare early, prepare often, get yourself ready, get your client ready. And I think those, from my perspective, are the tips on being a successful participant in mediation and having effective and efficient outcomes that you might like. So I'm glancing back down at my chat box, and I'm not seeing anybody pipe up or jump in with a question. I would remind everybody that I had a special edition of Uncomplex 2 days ago. It's out on YouTube and the podcast on Spotify. And it is a quick interview with Andrew Sabolic, who's the executive director of the Workers' Compensation Institute. And I spent about 45 minutes with him on Monday talking about where the Workers' Comp Institute has come and where it's going, what they're doing now that's different. Um, really pretty helpful if you're a new attendee and if you've been going to the workers' compensation conference for the last 3 or 4 decades, like some of us have. I still think that conversation with him is very helpful in terms of what's new and what's happening that can be, of course, valuable to you uh, and your clients. I'll just close with the fact that I look forward to next week. And one thing I really enjoy about the comp conference and about the forum is that folks will come up to me in the hall and they'll strike up a conversation. I really love conversations that begin with, I have an idea on how we could do things better. I really love conversations that begin with, have you ever considered a rule about this? Um, we would really love to hear from you. And so if you see me walking up and down the hallway at the World Center or next spring at the forum, by all means, I'd love to meet you in person. I'd like to chat with you about whatever's concerning you. The best opportunity for that this next week will be 5 o'clock in the Anaheim and Boston rooms, Anaheim, Atlanta, and Boston rooms. They're in the Hall of Cities for the OJCC meet and greet. I'll give one more chance for anybody to have a question, jump into the chat room, or if you want to, you can unmute and throw a curveball at me. And if not, we'll give that a countdown of 3, 2, 1, and we will conclude this issue, this episode of Uncomplex number 8, and we'll look forward to talking with you again in September. Thanks for tuning in.